Should have that. Have you got this? Yes.
Bon. Okay.
Buonasera a tutti e benvenuti. That's all the Italian that I'm prepared to say tonight, although it would be nice if we could all do this in Italian, wouldn't it? Good evening. Very warm welcome to everybody. I was thinking of presenting myself, but then, you know, since we're all colleagues here, never mind. I'll say who I am. My name is Stathis Banakas, and I'm a reader in the School of Law here at UEA. Tarcisio Gazzini began his academic career at the historic University of Padua in Italy, which was founded in 1222. I believe it's the second oldest after the Alma Mater Studiorum, the University of Bologna. And he went on to gain a master's in international law from the University of Nottingham before returning to Padua, where he wrote a PhD again in international law. Tarcisio has taught and researched in various areas of international law, with a specialization in the law of foreign investment, and in, among other places, the Universities of Padua, Glasgow, the Free University of Amsterdam, Lausanne, and of course now here at UEA. And we are delighted that we have such a great expert of public international law, general public international law in our faculty. Of course, we have also a couple of other distinguished colleagues in that area, but I can say that public international law now has become a very strong part of what we teach and research. But Tarcisio is not only a teacher and a researcher, he also has trained judges, lawyers, government officials, and has advised governments between 2014 and 2017. He also co-directed a research project on foreign investment in Africa, led by the Universities of Lausanne and Geneva, and with the support of the Swiss National Research Council. He is currently a visiting professor at the Graduate Institute of International and Development Studies in Geneva, as well as the Geneva Academy of Human Rights and Humanitarian Law. He's a member of the International Law Association, the Committee on the Role of International Law in Sustainable Natural Resource Management for Development. In 2012, Tasiccio co-founded a book series on international law published by the very distinguished European publishing house of Brill, which is also an international publishing house that publishes in the Netherlands, Leiden, and also in America, in Boston. And this series has already 14 titles and another 4 titles in the pipeline. He has also written extensively on topics across the subject, from the use of military force to economic sanctions, from international organizations to foreign investment. His publications include The Changing Rules on the Use of Force in International Law, which was published by Manchester University Press in 2006, and The Interpretation of International Investment Treaties, published in 2016 by Hart Publishing in Oxford. Not surprisingly, foreign investment, and more precisely the evolution of foreign investment treaties, is the topic of tonight's talk. Tasiccio Gazzini was appointed as professor at UEA in September 2017. Please join me now in welcoming Professor Tasiccio Gazzini to give his inaugural lecture.
Thank you very much, Statis. Dear parents, colleagues, friends, good evening, and thank you very much for coming. It's a great pleasure and honor to be here this evening. Before starting, if you allow me, I got 2 personal thoughts. The first one goes to this university. I must confess that when I applied for this position in 2017, I had never visited Norwich or its university. All I knew was that Norwich was a fine city and UEA a well-respected university. So I was a true outsider. And yet I was invited for an interview and given a real opportunity and a wonderful position and eventually a permanent contract. And this is quite remarkable, especially if you come from continental Europe. The second thought goes to my mother. She was 6 at the end of World War II, and the situation in Italy was rather dramatic, to the point that my grandfather had no means to feed 7 children. So he was obliged to put 2 of them, including my mother, in a religious institution on the shores of Lake Garda. But in spite of the gorgeous location, the place was, for all practical purposes, like a prison, with 2 important differences. The first one, the business was run by nuns. And the second, the guests had committed no crimes. But obviously, my mother could not get the education she was craving for. Remarkably, she managed to transmit her passion for studying to my brother and myself. If I'm here tonight, it's also thanks to her encouragement. Now, enough of the emotional stuff. Let's move to the academic content of this evening. The topic I've chosen is the evolution of investment treaties, which are treaties states conclude to legally protect their respective investors, normally multinational companies, investing abroad. These treaties add an international layer to the legal protection investors already enjoy under domestic legislation and contracts. They contribute to creating a legal environment attractive to foreign investors in a highly competitive global market. Today, virtually all British universities offer courses on investment law, of which investment treaties constitute an essential part. But the subject is rather new in the curriculum, as until 1990, investment law remained a rather esoteric topic, reserved to a small circle of specialists. Then, in the 90s, the subject literally exploded, as we will see in a moment. If I can inflict you a personal anecdote, in 2006, I suggested the School of Law of the University of Glasgow introduce a course on foreign investment law. The initial reaction from the head of school was, which kind of subject is that? Nonetheless, he let me go ahead, and eventually the school was one of the first in the country to offer this course, which immediately became very popular. In spite of its young age, however, investment law is already in its middle age crisis, or, according to some pessimistic views, even seriously ill. From this perspective, investment treaties have been described as toxic legal instruments. Now, many states seriously doubt that these treaties are beneficial to their sustainable development and consider them as obsolete, and some of them are trying to get rid of them. The questions I'm trying to answer today are investment treaties so bad? Certainly they have certain shortcomings, but are we sure that the situation is beyond repair? Well, this is why it's a good idea to have a closer look at these treaties, which are at once important and intellectually stimulating. Their importance is self-evident in an increasingly interdependent and globalized world, in which geographical barriers are more and more permeable to business. It is true, the findings of several empirical studies on the relationship between the conclusion of these treaties and economic development are not consistent. There is, however, general agreement that foreign investment are, at least potentially, a vehicle for economic growth, sustainable development, creation of jobs, and transfer of technology. The flow of reinvestment has dramatically increased in the last couple of decades, reaching its peak in 2008, before the financial crisis. But there is more than just a quantitative increase. The flow of reinvestment has become today a truly global phenomenon, as according to UNCTAD, the volume of investments for companies of emerging economies and developing countries has recently overtaken that of investments from companies from developed countries. In the chart, you can see in orange investment from companies from developed countries. In the dark green, investment from developing countries, and in the light green, investment from emerging economy. But investment treaties are not only important. There are also intriguing because they essentially aim at regulating the legal relationship between two radically different subjects. On one hand, the host state, the sovereign state where the investment has been made, and on the other hand, the investor, a private entity. This has paved the way to several significant developments in the international legal order and the way we look at it. This evening, I would like to deliver a broad overview of these treaties and describe how they have evolved in the last few years and how they could evolve in the future in order to meet the needs of today's society. In answering these questions, I will identify the main concerns raised by these treaties and how states have addressed them. At Herlam Hall, the beautiful home of the School of Law, we obviously focus on legal issues. This is our job. We are nonetheless aware that legal issues are just a part and not necessarily the most important one of a much broader picture in which economic, social, and political issues may often be predominant. With regard to foreign investment, in particular, when a multinational company decides whether and possibly where to invest abroad, it must consider a multitude of elements, including, most prominently, market opportunities, infrastructures, political stability, currency and financial conditions, human resources, and at some point also the legal protection it can expect in any given country. Let's start with some preliminary considerations on the instruments providing legal protection to foreign investors. There is no multilateral treaty on foreign investments comparable to the treaties governing international trade, notably those concluded within the World Trade Organization. States have attempted a couple of times to conclude such treaty, but without success. In 1996, in particular, a multilateral treaty on investment was negotiated within the Organization for Economic Cooperation and Development, which is the organization of the developed states. The negotiating states, however, could not go beyond a consolidated draft of the treaty because of disagreement on key issues. Therefore, no treaty was concluded. In the absence of a multilateral treaty providing for rules applicable to all states, foreign investments are today governed by a complex and heterogeneous web of different legal instruments. The most important of these instruments are international treaties, domestic legislation, and contracts. First, states have concluded more than 3,000 investment treaties. The great majority of these treaties are bilateral agreements or free trade agreements, which include a chapter or section on the protection of investment, such as the recent Comprehensive Economic and Trade Agreement, known as CETA, concluded between the European Union and Canada, which regulates both trade and investment. Second, a large number of states have adopted legislation, often referred to as investment codes, offering legal protection to foreign investors at the domestic level. The 2015 Investment Act, enacted by South Africa, is a good example. Third, and finally, complex investments, such as infrastructure or natural resources projects, often require the conclusion of so-called state contracts, meaning contracts between the host state and the multinational company. These legal instruments, treaties, legislation, and state contracts belong to different legal orders and are quite different in nature. Nonetheless, they all concur in creating a stable and predictable legal environment for foreign investments, with the objective of stimulating private business, promoting economic development, and hopefully creating jobs and improving the living conditions of the local population. This is the general framework. It is now time to zoom in on investment treaties. The first investment treaty was concluded between Germany and Pakistan in 1969. Since then, these treaties have proliferated at an incredible pace, especially in the 90s, when states were very excited about this kind of treaties, although they did not always fully realize their implications. Nowadays, we have 2,658 bilateral treaties in force, and the United Kingdom is currently bound by 93 bilateral investment treaties. The last one was concluded in 2010 with Colombia, and 56 free trade agreements containing investment provisions. With regard to the content, investment treaties have been traditionally very simple. They normally contain just a dozen of provisions, including the final provisions. They typically provide for a few substantive standards of treatment foreign investors are entitled to, as well as provisions on the settlement of two types of disputes. Dispute between states, which is definitely the exception, and disputes between the investor and the state, which is definitely the rule. Let's start with the standards of protection. As mentioned earlier, these treaties are intended primarily to legally protect investors in their dealings with the host state. When a multinational company invests in a given country, it is subject to the jurisdiction of that country and must comply with the rules and the regulations in force in that country. Investment treaties impose upon the host country certain obligations on how its sovereign powers must be exercised. In other words, by concluding an investment treaty, a state commits itself, as a matter of international law, to respect certain standards of protection. Failure to comply with these obligations would amount to a breach of international law and engage the responsibility of the state. It is worth noting that these provisions are reminiscent of the provisions we can find in administrative law at the domestic level. This is not a surprise, because the treaty, like administrative law, governs the exercise of public authority over private entities. A typical investment treaty contains four main substantive standards: fair and equitable treatment, expropriation, full security and protection, and return of benefits. The first two, fair and equitable treatment and expropriation, the first and the third, are by far the most important ones, and indeed account for more than 90% of investment disputes. Fair and equitable treatment means that the state must act in good faith, respect procedural property and due process, and refrain from adopting arbitrary, discriminatory, or incoherent measures. Expropriation is the nightmare of every investor. It can be direct when it involves the transfer of property from the investor to another entity. Direct expropriation is nowadays the exception. A good example is the expropriation which occurred a couple of years ago of Repsol, a Spanish energy company, by the Argentinian government. Expropriation can also be indirect, when the investor is not formally deprived of the title to property, but is prevented from effectively enjoying the investment. Indirect expropriation has become by far the most recurrent form of expropriation, although establishing when the conduct of the state prevents the investor from enjoying its investment has proved particularly difficult. This is not peculiar to foreign investment law, and analogous problems can be found in domestic administrative law. In the United States, for instance, indirect expropriation would be called regulatory taking. I will revert to this point later. For the time being, it is important to emphasize that these substantive provisions have significantly improved the legal protection of foreign investors. The real breakthrough brought about by investment treaties, however, relates the settlement of disputes. Before these treaties, foreign investors had only two remedies: bringing their cases before domestic tribunals or applying for diplomatic protection. Neither remedy was really effective. Domestic tribunals were often unable to offer adequate protection to a range of reasons, including lack of independence, poor competencies, political pressure. Diplomatic protection, in turn, depended entirely on the diplomatic decisions or the political decisions by the national government. It was indeed entirely up to the government to decide whether and how to intervene to protect the investor. By bringing a claim against the host state, the government relied on a legal fiction as held by the Permanent Court of International Justice in 1994, and I quote, "By taking up the case of one of its subjects and by resorting to diplomatic action or international judicial proceedings on his behalf, the state is in reality asserting its own rights, its right to ensure in the person of its subjects respect for the rules of international law." The government was accordingly in full control of the dispute. Compensation, if any, was due to the government itself, not to the investor. And of course, these arrangements were hardly satisfactory for the investor. Investment treaties introduced a paradigm shift in the settlement of disputes between foreign investors and the host state. Disputes are now primarily settled through investment arbitration, which is modeled after international commercial arbitration. Almost all investment treaties give the investor the right to request the constitution of an arbitral tribunal, normally composed of 3 members, one appointed by the investor, the second one by the host state, and the chair by the 2 members. The tribunal is only competent to settle the specific dispute for which it has been constituted and delivers a final and binding decision, and no appeal mechanism is available yet. Furthermore, and contrary to international human rights, investors do not need to exhaust domestic remedies before bringing their claims before arbitral tribunals, unless this is expressly required by the treaty itself, which remains quite exceptional. The idea behind investment arbitration is to take the dispute out of the reach of the host state, to have a decision from an international and independent tribunal, and to insulate the dispute from any possible pressure or interference by any entity. As pointed out by a tribunal, an investment tribunal offers to investors assurances that disputes might flow from the investments would not be subject to the perceived hazards or delays and political pressure of adjudication in national courts. These developments meant the full emancipation of the foreign investor. The investor is now in full control of the dispute, and the investor may be entitled to compensation. He has to rely on the national government only if the host state fails to comply with the final award. In practical terms, it means that a dispute between a British investor and the host state, let's say India, concerning alleged violations of the treaty between the two countries is settled by a tribunal composed of 3 private individuals appointed by the parties. One by the British company, the second one by India, and the chair by the 2 members. The 3 individuals may meet in Washington, Geneva, or Singapore, and they deliver a final and binding decision, possibly granting compensation to the British investor if the claim is successful. In the last couple of decades, this type of arbitration has literally exploded, and now almost 1,000 disputes have been reported. Not surprisingly, investment arbitration often involves enormous financial interests. The record compensation was $52 billion, which was granted in 2014 to UCO's shareholders in 3 twin disputes against the Russian Federation. Incidentally, the case is currently challenged before Dutch tribunals. But this level of compensation is abnormal. However, if you consider this abnormal case, the average amount of compensation is $500 million. If we exclude the abnormal UCO's case, the average amount will go down to $125 million. How have these tribunals performed? The press has often reported that these tribunals are biased and tend to decide in favor of the investor. This is not accurate. Empirical research has showed that the number of decisions in favor of the host state are significantly higher than those against the state. According to UNCTAD, investment tribunals have decided in favor of the state in 230 cases, and in favor of the investor in 191 cases. This was the broad overview of the historical development of the treaty protection of foreign investments. In the last few years, however, these treaties have attracted a good deal of criticism and raised 3 main concerns amongst governments, in academia, and in the public opinion. The first one is the unbalanced nature of these treaties. Are they normally impose obligations exclusively on the host state and grant rights exclusive on the foreign investors? The second concern is the lack of safeguards for the exercise of regulatory powers by the host state, which often refrains from taking measures for the public interest, especially for the protection of the environment, labor standards, public health, and so on, in order to avoid any risk of arbitration and possibly compensation. The third concern is the lack of legitimacy of investment arbitration, which does not offer sufficient guarantees in terms of transparency, public scrutiny, and public participation. There is no doubt that these concerns are real, to the point that some scholars have declared that the system is in a state of chaos or facing a serious crisis. States have reacted differently to these concerns. It is possible in the first place to detect a general reluctance by states to conclude new investment agreements. Since 2012, only 25 investment agreements have entered into force. Although there is an opposite trend with regard to regional arrangements, and we have recently the conclusion of a number of important regional treaties containing provisions on investment, like the treaties concluded by the European Union with Canada, Vietnam, Korea, Japan, or the Trans-Pacific Partnership Agreement. Besides, several states have terminated a number of these agreements in accordance with the terms of the agreement themselves, especially India, Indonesia, and South Africa. Third, some states have replaced the protection normally given by treaties by introducing specific pieces of legislation, as in the case of South Africa, which in 2015 enacted the investment code. And finally, some states have upgraded their investment treaties, like in the case of the treaty concluded between Morocco and Nigeria in 2016, but not yet in force. For the purpose of this evening talk, we focus on the last development, namely the upgrading of investment treaties. The exercise aims at rebalancing the content of these treaties, better protecting the regulatory space of the host state, and increasing the legitimacy of investment arbitration. Starting with the first concern, the manifest unbalanced consent of this treaty. As I said earlier, virtually all these agreements contain obligations only for the state and rights only for the investor. Quite a bizarre way to regulate the legal relationship between two entities and to strike a balance between all private and public interests involved. This is why investment arbitration is almost systematically between the investor as applicant and the state as respondent, with very few exceptions. As a matter of fact, however, the content of investment treaties is not a new problem. It is interesting to note that in the aftermath of the unsuccessful attempt I referred to earlier in 1896 to conclude a multilateral treaty under the auspices of the Organization for Economic Cooperation and Development, the House of Commons Trade and Industry Committee strongly criticized the way negotiations were concluded, because environmental, public health, safety, and other standards were almost systematically neglected. And the conclusion of the committee was a recommendation that in any future negotiations of a multilateral investment, the protection of regulatory standards be of central concern. It looks like the narrative of an NGO, but in reality is the very balanced and objective assessment of a business committee of the House of Commons. Now, to what extent have states followed the advice of the committee, which has been shared by international organizations and elaborated in scholarships? The short answer is states have largely ignored the advice. But a significant number of states recently have taken a more balanced approach towards investment treaties. This treaty certainly continues to provide foreign investors a favorable, stable, and predictable legal framework. This is necessary in order to attract foreign investments in a highly competitive global market. But some recent investment treaties also protect the interest of other stakeholders. And in particular, they protect the environment, public health, labor standard, human rights, and also the redistribution of the profits generated by investment. We have no time to go through all these issues, but we can afford a couple of brief considerations on the protection of the environment. Recently, states have designed a few provisions meant to enhance the protection of the environment and to minimize the negative impact investment may have. The most traditional provision simply imposes upon states the obligation not to relax environmental, human, and safety standards in order to attract foreign investors. An example can be found in the recent United States Model Bid, Article 12(2), according to which the parties recognize that it is inappropriate to encourage investment by weakening or reducing the protection afforded in domestic environmental law. This kind of provisions is intended to prevent a race to the bottom in which states sacrifice their environmental standards to the altar of economic development. Provisions like Article 12 of the US Model Bid are obviously a step in the right direction. But states can be much more proactive in managing the possible consequences of foreign investments for the environment. The most efficient manner to minimize such risks is to impose upon investors the obligation to carry out an environmental impact assessment when planning an investment which may potentially have adverse effects on the environment. A good example is the ECOWAS Treaty on Investment, which is very innovative, for it contains separate sections on the rights of the investor, the host state, and also the home state, the national state of the investor. And according to Article 12 of the treaty, investors and investments shall conduct an environmental and social impact assessment of the potential investment. Investors or the investments shall make the environment and social impact assessments accessible to the local community. Investors, the investment, and the host state authorities shall apply the precautionary principle to their environmental and social impact assessment. This is quite revolutionary for this kind of treaties. Although the obligation to carry out an environmental impact assessment already exists in the legislation of the overwhelming majority of states, it is still important to reiterate in a treaty as a matter of international law. This brings us to the second concern, namely the safeguard of the regulatory space of the host state, which is often perceived by states as insufficient. Here the problem is to ensure that the host state is able to exercise its sovereign prerogatives and meet its responsibilities related to the protection of public interest without being unduly exposed to the risk of international arbitration and claims to compensation by investor. The question is particularly delicate as we need to strike a balance between the right of foreign investors to properly manage and develop their investments on one hand, and the right and duty of the host state to take the measures indispensable to protect public health, the environment, public standards, and so on the other hand. It is undisputed that regulatory measures adopted in good faith and in a non-discriminatory manner by the host state may have detrimental financial or economic effects upon foreign investors without any need to pay compensation. Yet, it is equally undisputed that regulatory measures may be so intrusive and heavy to deprive the investor of the enjoyment of the investment. Or, in other words, they amount to indirect expropriation. In this case, the host state is bound to fully compensate the investor. Unfortunately, drawing the line between non-compensable exercise of regulatory powers and compensable indirect expropriation is a very complex exercise. As investment tribunals have regularly pointed out, there is no one-size-fits-all formula. Quite the contrary, in deciding whether the government has crossed the line, it is unavoidable to adopt a case-by-case approach and to take into account all relevant elements. This is neither surprising nor peculiar to foreign investment, as domestic tribunals often face similar challenges. The jurisprudence of the United States Supreme Court, for instance, offers many examples in this regard. And interestingly, according to one of the most influential judges of the Supreme Court, Justice Holmes, in cases of regulatory taking, which is the equivalent of indirect expropriation, the tribunal must establish whether, I quote, the government has gone too far. In this case, the obligation to compensate is triggered. The question is now how investment treaties can draw a better line and ultimately better protect the regulatory space of the host state. States have designed a few provisions to reduce their exposure to investment arbitration. Some treaties have borrowed a provision contained in the 1994 General Agreement on Tariffs and Trade, the most important international trade agreement. Article 20, GATT, allows states to take the measures which are necessary to protect several categories of public interests, provided that the measures are not a pretext to discriminate imported products against domestic products. In its translation into an investment treaty, this provision looks like Article 10 of the Canadian Model Bid, according to which the host state may adopt and enforce the measures necessary to protect, inter alia, human, animal, or life plant health, provided that these measures are not arbitrary and discriminatory. As in the case of international trade, whether these measures are indeed necessary and consistent with these provisions call for a delicate assessment by investment tribunals. Some states have taken a further step and opted for a different type of provision, according to which the host state is not entitled to take the measures necessary to protect the public interest. The host state is entitled to take the measures it considers appropriate to protect the public interest. And in this case, the provision becomes almost entirely self-judging, and investment tribunals must show the greatest deference and do not need to pass a judgment on the necessity of a given measure. Rather, the scrutiny by the tribunal is limited to verifying whether the host state has acted in good faith and not abuse of its rights. Moving to the third concern, the settlement of disputes. Investment tribunals have been criticized on numerous grounds, including, most importantly, the lack of consistency, transparency, public participation, public scrutiny, and adequate provisions on conflict of interests. All these concerns are widely shared, and governments, as well as international organizations, have been quite active in attempting to address these concerns. I limit myself to a couple of interesting developments. Lack of consistency. Each investment tribunal is sovereign, which means that it's not legally bound by any previous decisions. Of course, tribunals will carefully review and look at the relevant decisions, but they're not formally obliged to follow them. Furthermore, their decisions is not subject to any form of appeal. As a result, investment tribunals may and have indeed delivered
inconsistent decisions on several important issues. And here is the first important development. In order to increase legal certainty and predictability, the European Union and Canada, in the Comprehensive Economic Agreement, they have envisaged to create an appeal mechanism and to create a permanent investment court. These developments have been inspired by the World Trade Organization appellate body and are expected to increase legal predictability and certainty of investment arbitration. Last July, the Court of Justice of the European Union held that the creation of such a court is consistent with European Union law. With regard to the lack of transparency, public scrutiny, and public participation, suffice it to mention that arbitral awards are not always available to the public, even if compensation, if any, is paid by taxpayer money, unless publicity is required by the relevant treaty or the parties have agreed so. The concern is obviously real, as disputes systematically involve public interest, such as the exploitation of natural resources, public utilities, infrastructures, and so on. The model bit adopted by the United States contains several provisions in this regard. According to Article 12 and 29, the host state has an obligation to publish laws and decisions concerning the investment, to make available to the public the documents relating to arbitration, and, in principle, to open the hearings of arbitral tribunal to the public. On transparency, I just need to mention the conclusion in 2014 of the Mauritius Convention, which unfortunately has been ratified so far only by 5 states, which is a strong reminder on how states are often prone to criticize investment arbitration, but reluctant to commit themselves in international treaty. Another important development is the adoption by UNCITRAL of a set of rules on transparency in treaty-based investment state arbitration. Both important development towards a more transparent and accountable investment arbitration. And yet, there is another important question we need to address. So far, we have discussed disputes between the investor and the state. More than 1,000 disputes. In other words, disputes related to claims brought by the investor against the host state. But what about the liability of foreign investors? As we have seen, investment treaties offer a uniquely solid protection to foreign investors. Yet, they do not normally include any obligation for the investor. And therefore, it's impossible for the investor to bring a case against, for the state to bring the case against the investor. And even when, exceptionally, investment treaties contain obligations for investors, these obligations do not fall within the arbitral clause. At best, therefore, states can file counterclaims within proceedings brought by foreign investors. For the time being, therefore, since arbitration is not open to states with regard to claims against the investor, the question of the liability of investors must be discussed at the domestic level, in the sense that claims must be filed before domestic tribunals. Unfortunately, domestic tribunals do not always offer proper guarantees or adequate compensation to the victims of wrongdoings committed by multinational companies. Under the circumstances, the complainants, the victims of these wrongdoings, could attempt to institute proceedings against the foreign investors before the tribunals of the investor national state. For example, the Indian victims of wrongdoings committed by a Canadian investor could try to file a case and seek compensation before a tribunal in Canada. Different legal hurdles may eventually prevent them from obtaining satisfaction. The most typical problem is the so-called forum non-convenience doctrine, which are different meanings in different countries, but essentially means that domestic tribunals may decline to exercise jurisdiction if the tribunals of another country are deemed more appropriate. From this perspective, the development I mentioned earlier relates precisely to the access of the tribunals of the national state of the foreign investor. A significant number of modern investment treaties, including the ECOWAS Treaty, contain specific provisions that commit the national state to ensure, I quote it, to ensure that the legal system and rules allow for or do not prevent or unduly restrict the bringing of court actions on their merits before domestic courts relating to the civil liability of investors for damages resulting from alleged act or decisions made by the investor. The same provision has been reproduced in the 2015 Indian model bid. The intention of the Indian government is clearly to ensure that the victim of wrongdoings committed by foreign investors in the territory of India have access to domestic tribunals of the investor in case such as the infamous Bhopal incident, in which the foreign non-convenience doctrine precluded the victims from obtaining justice and compensation before United States tribunals. The Indian model is particularly important not only because it will be used to draft the treaties negotiated by India, but also because it may be expected to inspire the attitude towards investment treaties of other states, and in particular, emerging economies and developing countries. The big question is that it remains to be seen how states will honor these obligations, and in particular, to ensure that the legal systems and rule allows for or not prevent or unduly restrict civil action before the national tribunals. However, the development is extremely important, especially if you share the view taken by Joseph Stiglitz, Nobel Prize for the Economy, according to whom recognizing corporate liability will not harm economic development of least developed countries, United States businesses operating abroad, or investment in the United States. Quite the contrary, for Stiglitz, it will be beneficial also for a purely business perspective. So which conclusions can we draw? Investment treaties are still very young, and probably they have grown too fast. It is probably physiological that they suffer from some serious shortcomings that have attracted a good deal of criticism. States are fully justified in questioning whether or not these states are beneficial to their sustainable development. In my opinion, it is probably too early to throw these treaties in the rubbish bin, as several states have already done. Treaties are neither bad or good. Their content and the use you make of treaties can be bad or good. We have already a significant number of provisions amending these treaties with a view to better strike a balance between all private and public interests at stake. The provisions on the protection of the environment and the liability of multinational companies clearly prove that states can, if they want, bring these treaties in line with the needs of modern society. In other words, international law offers the tool to tackle and correct the problems affecting investment treaties, provided states are prepared to take advantage of them. The innovative provisions we have seen this evening are welcome developments, but they're still rather isolated and often provide only partial and incomplete answers. A profound and systematic reform of these treaties is needed to bring them in line with the development of international law and more generally society. The fact that most of these treaties are bilateral is a clear advantage, as amending and updating them is much easier than amending and updating a treaty with a large membership. The exercise may be rather complex, as it involves balancing the different and often conflicting private and public interests in a transnational environment. Reconsidering these agreements should not be the exclusive prerogative of governments. Legal scholars should engage in the debate on how to optimize the legal protection and ultimately the impact of foreign investments, and enhance at once their legitimacy and fairness. Additionally, this is a particularly fertile ground for interdisciplinary research. Finally, in case we have missed any reference to Brexit, there is a short footnote. Since the entry in force of the Lisbon Treaty, the European Union has exclusive competence with regard to foreign investment. When, or better if, the United Kingdom leaves the European Union, the British government will regain full control over foreign investment policy and investment treaties. This means that it will be for the British government a great opportunity and challenge to reconsider and possibly upgrade its investment treaties, a significant part of which were concluded decades ago and are now obsolete. Keeping in mind the clear advice of the House of Commons Trade and Industry Committee mentioned earlier, it will be crucial for the British government to strike a balance, a better balance between the interests of the various stakeholders. Thank you.
Thank you very much, Tarcísio, for this very perceptive and clear analysis of a very complex but also very important legal phenomenon, the investment treaties. We have some time for questions, if you don't mind, from the audience. Can I suggest that you tell us who you are before you put your question to Tarcísio? Any questions? Please. Where? No, because we have people here that are not at UEA. That's
My question to you is, you mentioned before the multilateral courts for investment and the attempts that the European Union are making in order to establish a court based on the appellate body of the WTO. I can see the cosmetic advantage of such a move because everybody hates arbitration, private, hidden, justice, etc., etc. But my question to you, if you think that there is also substance in this move, if it will make any real change, and if it will lead to any changes in the perception of the investment law system in the eyes of the general public.
I think there are two independent questions. One is transparency, which is independent from the possible creation of an appellate mechanism. So we have already some rules on transparency, and we can apply these rules everywhere, even for the traditional investment tribunal. What we expect from the appellate mechanism is enhancing the consistency and to reduce the cases in which we have conflicting decisions. We have a number of key issues in which tribunals have taken completely opposite decisions on basically the same type of disputes. Unfortunately, states are quite reluctant to intervene because states could intervene and clarify the meaning of the treaties, but for some reason they are very reluctant to do so. So my question is, we may have fairly high expectations from the establishment of an appeal mechanism, which of course will be binding only within the treaty between the European Union and Canada, but can also be a source of inspiration outside the area.
Yes?
I'm Yusuf Farah from the School of Law in the UK. I mean, you probably know how I feel about this area. My main concern is that arbitration, in particular investment arbitration, other than which you perfectly described the inconsistency and we don't have the mechanisms at the moment to deal with it, is that the deterrent effect that arbitration could have on the regulatory space of the state, particularly small nations. I mean, I've read on a few occasions that a state like Indonesia and Malaysia had to change their policy. Even the UK, I mean, let's think about the PMI dispute on plain packaging of cigarettes. It didn't even have to get to arbitration. The state had to change its policy on important matters like health, climate change, environment, education, and all of that, simply because they were just simply saying it's too expensive, we don't want to get it, we don't want to go there. So it seems like there are, and I sometimes felt that these treaties are, in a way, post-colonialist tools, instruments, just to make sure, okay, we've withdrawn our armies from these poor developing states, and one way to make sure that we are still in control will how we enter into these treaties. We've seen these in the 70s between Argentina and many of the, and Spain, for example, where basically after 20, 25 years, Spanish companies managed to get lots of money out of the Argentinian government. Same with American companies. So there is something inherently unfair about these investment treaties and the mechanisms that make sure that they operate in favor, and I would say that in favor of the investors, even if they only win 46% of the cases.
Thank you. The basic assumption behind these treaties is that both parties may win. The state, because many states desperately need investors to develop infrastructure projects and so on. But on the other hand, they need to protect, to afford, to ensure legal protection to the investor. And the two can create some tension. We should refrain from taking extreme views. Normally, there are good governments and bad governments, good companies and bad companies. The purpose of the exercise is to strike a balance between, on one hand, creating a stable, predictable legal framework for the investor, and on the other hand, allow the state to develop. And, of course, we must protect the right and the duty of the state to regulate. But it's possible to introduce this kind of provisions in order to reduce the exposure, if I'm answering your question. Clearly, we are talking about the legal relationship between two completely different entities. These problems are not peculiar to foreign investment. They are also in domestic law. They are amplified because here we have a transnational environment, a foreign investor and the host state. Okay? So we can, in the first place, you just take an holistic approach. On one hand, it is possible to improve the content of these agreements and to introduce obligations for the investor. On the other hand, we can better protect the regulatory powers of the state, meaning to ensure that the state is able to protect public interest. And please.
Follow up, sorry.
1 minute.
Even less. And so these new generation treaties, will they have retrospective effect on investments that have already
no, on Article 28, the Vienna Convention, unless the party agrees so.
Unless it's distinct.
But the main point, the main message is states should stop complaining about this agreement and they have all the means to modify, to amend, and nowadays it takes just an exchange of email to clarify the meaning of the treaty, and it's very easy to amend the treaty, especially if it's a bilateral treaty. An exchange of letters, they can clarify and amend. Unfortunately, states are very reluctant.
David.
David Mead, I'm also a colleague in law school. I think it follows on from that question. This is not my area at all, Dodgy, as you know. I was wondering if there's been any work, empirical work done on the terms in these large number of bilateral treaties. Because it's one thing to talk about them in general terms, and it would be another, I would have thought, to look at what is the frequency of standard X or standard Y as between two developed, say the EU and Canada, reasonably equal bargaining power if they're entering into a treaty, and then between the EU and Colombia or other countries. And I'm just wondering whether there's any work that's been done on distinguishing those sorts of things.
Yeah, and all these treaties are available at the UNCTAD website, and it's also possible to have real data, empirical data concerning specific provisions. Traditionally, these agreements were very similar. If you compare the thousands of agreements concluded before 2000, they are very similar, very simple, the same provisions. Nowadays, we have increasingly sophisticated agreements. Of course, the agreement is the outcome of negotiations between the parties, so it's entirely up to the party to decide. The other point is about empirical studies. It has not been proven that the conclusion of these agreements will indeed bring development for the country. Okay? But because the content, up to 10 years ago, the content was very similar. These agreements were standard. Nowadays, states have, the important states, United States, Canada, European Union, they have a model treaty which is increasingly sophisticated. And most of the time, there are very detailed provisions concerning the settlement of disputes, the hearings, the documents, public participation, and so on. But of course, you have a very complex framework, mostly bilateral. So the development is quite irregular, depending on the needs of each specific state. And of course, some states are simply the recipient of foreign investment, some states are simply investing, some states are both. And depending on the interest of the state, you can adopt one or another provision.
Can I abuse a little bit my role as chair and ask you a question? Triggered by your reference to the Bhopal disaster in India, and when you were talking about access to the domestic courts of the investor. Obviously, the main reason why a state would like to have access to the domestic courts of the investor is if the investor comes from a rich country, obviously, not only rich country, but a country that has very developed mechanisms of civil liability and so on. And the United States is always the first choice of everybody. If anybody can actually sue an American company in the United States, and there's a whole history of how lawyers tried to use the Alien Torts Act in the United States and so on. And of course now the Supreme Court has rolled back the Alien Torts Act and so on. But this is really about not a violation of investor obligations, but it is about real injury that is done, which is in a way not necessarily linked to the contract itself. It's linked to the activity that the investor is allowed to carry on. And as we say, this is not a contract problem, it is a tort problem, yes? And now in this, and of course, again, another very important aspect of this is that, as you said, a lot of investment is about infrastructure, but there's also investment that is not infrastructure, like the Bhopal investment, which was mainly, I bring my money in your country and I give work to your workers. That kind of investment. So is there any way, do you see any future in, because that's one of my special interests, do you see any future of any mechanism of sort of global redress of issues? I mean, you talked about the International Investment Court. Is there any demand or any talk about some sort of global justice for losses and injuries caused, particularly in developing countries by those big multinationals?
Okay, 2 points. The Alien Tort Act is quite different because under the Alien Tort Act, civil action is possible before US tribunals, even if the perpetrator is not an American citizen, the victim is not an American citizen, and the offense has been committed outside. So
but even if they are American citizens?
On the contrary, these provisions have a clear link because the company is the national company of India or the other contracting party. The second point is what is remarkable is the evolution of the role of the national state, because we started with the role limited to protect the national investors. At the time, even by military force, the so-called gunboat diplomacy. So the role of the host, the national state, was to protect the interest of the investor. Here, we have moved far away, because now we have obligation for the national state to make it easier for the victims of the wrongdoings made by the company to bring a case before its own tribunals. So it's a completely different role by the national state.
But is there any international law about that?
No, this is clearly a matter of treaty law. And incidentally, the provision I refer to in the India Model Treaty has not been included in the first treaty concluded by India with Belarus, which means on a bilateral basis it was impossible for the party to agree on this provision. Everything depends on what the parties are prepared to put in the treaty. But the possibility is there. The problem is, will state accept this kind of obligations? Will state accept to open their tribunals for this kind of disputes?
But if under the general principles of private international law, the parties agree that the domestic state of the investor will have jurisdiction over the dispute, then private international law surely is enforceable, isn't it?
It is an international treaty, public international law treaty, and the content of the obligation is simply for the state to promote, to make access to the tribunals not unduly difficult. Okay? So the big question is, what does it mean in the obligation? So what is India or the other state expected to do in order to honor this obligation? In this case, we need the introduction of domestic legislation improving the access to tribunals. Okay? So in this case, it will be more difficult for tribunals, for instance, to decline jurisdiction because of the foreign convenience. So you have the international obligation between the two states, and then the implementation at the domestic level, which can be different between different parties.
Thank you. One final question, perhaps? Right, so again, Tasicil, thank you very much. Thank you. You're all cordially invited to share with us a glass of wine outside the theatre. Thank you. Grazie mille.
Grazie.
We should see if we can work together in some aspects of this, because I'm very interested in the total ability aspects.
Joseph too is very interesting.
I didn't know that.